Welcome, everyone. Welcome, everyone. Welcome to Tuesdays and Thursdays with Care Patrol. We are so happy to see you here today. It's a beautiful day in Birmingham, Alabama, where we are. I hope it is beautiful where you are. Today's edition of Tuesdays and Thursdays with Care Patrol, we will feature once again John Holliman. Some of you may have participated earlier last week when John went through types of care and payment options for care, including Medicaid. Last week, this week, John is kind enough to lend us his time to talk about the differences between powers of attorney, guardianships, conservatorships, and when each of those apply. And you all may remember from when John was with us before, John is a fourth generation Alabama lawyer. So his great grandfather graduated Alabama Law School in 1914. So John, his father, his uncle, his grandfather, all of these folks in his family had a history of serving people through family law. And that's where John started his career with his father, who's been practicing over 50 years. And then John pivoted, or really not pivoted, but added a branch of his services about a dozen or more years ago in becoming an elder lawyer and dealing with issues related to aging and care for the aging. And so now is kind enough to lend us his expertise once again. And I want to say that this topic that we have today was suggested, and you may see this if you read the chat room, you may see that this topic was suggested by one of our attendees. And so we're very serious when we ask y'all, if you have ideas for topics, we will try, if we can, to bring those to fruition for you. And similarly, your comments in the evaluation help us as well. Now, getting to that, let's do a little housekeeping as we're getting started. We will have a survey evaluation due at the close of this presentation. And in order to receive your certificate, you must participate or do an evaluation, in which case we hope you will give us some ideas and comments for how to improve or things to offer in the future. But the survey is through SurveyMonkey, and there are some of you who may have joined by phone. And so I will take just a moment to read to you the SurveyMonkey link address where you will go after the close of this presentation and conclude your evaluation. The SurveyMonkey link is https://www.surveymonkey.com/r/all uppercase G as in go, D as in dog, G as in go, G as in go, N as in no, HH. So the SurveyMonkey link, again, one more time for those of you by phone, is https://www.surveymonkey.com/r/all uppercase G, D, G, G, N, H, H. Now, there's also a password that you'll need. We'll give that later in the presentation, about 40 minutes in. And we have to do that because we want to make sure that you are here and participate and get the full educational hour and get the credit. And the state boards of nursing and the state boards of social work who credential us and allow us to do these CEUs mandate that we must prove that you are here for 40 minutes. So we'll give the CEU code word later in the presentation. Be looking for that in the chat room. Use that to get into SurveyMonkey. And once you've completed that, I'll send out certificates this evening. Can you drop the link in the chat? I just did, Pamela, but I'll do it again. Oops, wrong thing. Let me find it. Here it is. it's, I'll just do it one more time. Control C, everybody, Control V. There we go. It's in the chat again, Pamela. I hope you can see that. And now that we're at about 12:05, I'm going to be quiet. And I will, though, let me say this. If you have questions, you're all muted. So please use the chat room and ask your questions of John, and I'll pose those to him as all of you are muted. But we do want you to use the chat room. We want you to consider it a safe space to exchange ideas, ask questions, share resources, and we appreciate you so much. And John, I'll let you continue talking now, and I'll step aside.
Okay, thank you, Sean. This is a great thing that he's got organized here. Gotta love technology. So as Sean mentioned, I've been in a roundabout way, I've been practicing 32 years. And my wife, Melanie, who y'all may know, she's been practicing 17. And my dad just retired. He retired last year, but he's working with Melanie and I in Pelham, in the Pelham office. He practiced for 52 years. So between us, we've got a century of experience. But and we have the office in Pelham. I'm sitting right now in our Scottsboro office, Jackson County, and we just opened a Chattanooga office. So we are, needless to say, all over the place. But last week we talked about long-term care and ways to pay for it, as Sean mentioned. So we talked a little bit about veterans benefits, but just a little bit, because that's our next topic in a week or so. And we talked about Medicaid, Medicare, how the lay people don't understand the levels of care like we do, y'all do. But today is real important because this comes up, I mean, literally every day. Power of attorneys, problems, and how to avoid them. So let's jump right into that, if you will. Okay, get this screen situated. All right, so one of the first questions we ask is, does the client have an estate plan? So you may say, what in the world? A lot of people say, I'm just interested in elder law. I'm not interested in estate planning. I want to know how to pay for mom and dad. Well, the estate plan is still a vital part of the conversation. I say you can do estate planning without doing elder care law, but you can't do elder care law without looking at their estate plan. And one of those reasons is because you want to see about the power of attorneys. So we say, how old is the estate plan? Basically, are their wishes out of date? Or is the power of attorney substandard in some way? Is it valid for Alabama, or is it some state they moved from that, is not going to recognize that? It's not going to be recognized in Alabama. Now that's can be fairly rare. There's a doctrine called reciprocity, but in healthcare directives, it's more common. And then we get into those questions we asked last week. Has the client properly planned for long-term care? Are they private paying out of their own money? Are they set up for Medicaid at some point in the future? So you have the elderly people, and then you have their children. So is the family on board with all the options? And here we get to some of the crux of it. Does the client have the capacity, the mental capacity, or the legal competency to sign new estate planning documents? If not, does someone already have that legal authority over the client? So, been to obviously hundreds of seminars in my lifetime, and this is a lot of times where the legal seminars start. Does the client have capacity, or is there an acting power of attorney already in place? Try to situate this bar here. There you go. Okay, so power of attorneys, attorney in fact. Alabama actually calls the attorney in fact the agent, but we're guilty of it too. We say the person is the power of attorney. The power of attorney is really the document, and the attorney in fact is the agent. the person that has the powers to act? Are we looking at the most recent one? That's real important, because the first paragraph of every power of attorney usually revokes the last one. What specific powers are included? Does it authorize what we're trying to do? So you may think a power of attorney is just a form. Let's just grab one somewhere. It's only as good as the attorney and how he listens to know what to put in the document. They can be very powerful or they can be limited. So does the agent know that he's even the power of attorney? I did it again. The POA agent. What are the expectations of that agent to act for the person who needs the help? Is the agent very familiar with the client's preferences? So these are some of the questions we ask when we start talking about power of attorneys, but don't make that mistake in thinking that it's a form. Now, when we tell people to sign, using the power of attorney, there's an example on the screen on slide 4 there. Hopefully you're looking at that, that you sign the principal's name by the power of attorney, agent, or attorney in fact. So you're not signing in your individual capacity. You never want to sign you don't want, in this case, you wouldn't want Jane Smith just to sign a document that had the elderly person's name or the disabled person's name at the top. You want her to sign in her capacity. So y'all know what durable means. It means that it survives the incapacity. So there was such a thing, and you may think, well, why in the world would somebody want a power of attorney that if I'm incapacitated, it's no good? Well, that's a thing. If you were traveling to Europe and you said to your best friend, handle my affairs while I'm gone, it could be a non-durable power of attorney. In 2012, the state of Alabama said that our power of attorneys do not have to say durable anymore. So in other words, it's automatically going to survive somebody's incapacity. And then a limited power of attorney, think of that as when you what the car dealerships do when you sign that, so they can get you the title certificate. And then we'll go over healthcare power of attorneys, which everybody should have, and I'll tell you why. And then every once in a while, people are concerned about delegating the authority to somebody immediately because a power of attorney is so powerful. So if I give you a power of attorney, let me say it this way. If I give you my blank checkbook, what can you take from me? You can take what's in my checking account. But if I give you a power of attorney, you could take my house, my car. So a power of attorney is very powerful. So sometimes people say, well, I want this to only be effective if I'm disabled or if I'm incompetent. So we can make it spring into effect. And that triggering thing that makes it spring into effect is usually a doctor's letter. So those are the different types of power of attorneys. And sometimes people will even miss the fact that it's springing, like the bank. So that's why they stop and they run it through their legal department to see if it's, durable, if it's limited, if it only has healthcare powers, or if it springs into effect upon the occurrence of a certain event. So contrast somebody that you give the authority to in a power of attorney with a legal guardian. So a guardian is over the person's health and well-being. The court considers the statute, which gives a priority, but then the court has the ultimate right to make the decision, right? So it could be a family member, it could be a trusted volunteer, it could be a lawyer that doesn't charge for that service. It could be a lawyer that does charge for that service. It could be the same as a conservator, or you could have a legal guardian and a conservator as two separate people. One would be in charge of the health and one would be in charge of the money or assets of the person. So this is court appointed as opposed to a power of attorney that's privately done. Privately done, preferably with a lawyer, and I'll tell you why that provides so many safeguards. So again, conservators gives you access to financial information. A lot of times the power of attorney doesn't give us the powers we need. So we have to ask the court to do a limited conservatorship when we're applying for Medicaid. And, when you're applying for Medicaid to pay for somebody's nursing home, we don't really want a bunch of delays because it's costing them, between $6,000 and $9,000 a month. So every month is money. Every midnight of the last day of the month starts a new month. So again, the court considers who is trusted enough to be somebody's conservator with the money. Jefferson County has a county conservator, which y'all may know Sid Summey, and I think Sid's still the county conservator, and some other people that are high on the probate judge's list to be appointed. So that's power of attorneys / agent, guardians, and conservators. So here, let's run through some situations, and these, may ring true to you. These are real cases that we've had with the names changed to protect the innocent. So mom is throwing away all the mail and not paying her bills. Something as simple as going to the post office and changing her mailing address, or calling the utility companies. If they know that you're not her, if you're not impersonating her, and we don't recommend that, then you need a power of attorney for that, believe it or not. So this is we've had this case more than once. Mom is writing checks to every charity that sends a request to her, Publishers Clearinghouse. So of course that's a contest, but disabled veterans, the American Red Cross, Salvation Army, the ones that call a lot, and that's not necessarily a bad thing, but we don't want it to impact mom's financial security. And we don't want her to give away so much money that Medicaid is going to say that she made a disqualifying transfer penalty. And she's gone so far as to pawn her car title so she can send money to scammers. I got this call from a guy that I went to college with, and they were already clients, and his mother-in-law was a client, but living right there in the independent living of one of our facilities in Birmingham, with them visiting her all the time, she managed to give away $70,000 in different increments. One of those phishing scams where you have to give them some money and then they promise you something back. So do you have a power of attorney for her finances? Are you on her accounts? So, everybody comes in and they've got one or two children on their checking account, and that's generally okay. However, if she passes and the children don't get along, that bank account belongs to, let's say, one child that's on that account. So it's actually better to have the accounts all in mom's name and to have the power of attorney put on file with the bank when she needs help. Because the power of attorney, the agent, is a fiduciary. Let me check I guess Sean would tell me if any of just want to make sure the volume was good. Do you have online access to accounts so you can monitor how money is spent? And you don't necessarily need a power of attorney for that. You need the logins, right? And then there's these programmable debit cards that we use. Mainly the Alabama Family Trust uses them. And then of course there's the conservatorship, and these are solutions for this particular situation. So everything, as we say, turns on its facts. Everything's highly fact dependent. Okay, dad has been reported to you as a dangerous driver, but he will not stop driving. So you can try to reason with your parent or your patient or your whoever you come in contact with, you're in that role. And then if they refuse to cooperate, you can file a guardianship. So you're not actually seeking control over the money and the assets, but you're just getting control over the person. That's a court proceeding. There's got to be a doctor's letter. They've got to be adjudicated that they can understand what they're doing. And it's seen as taking away somebody's due process rights. So like if you were to come to me and you think that, or if you were related to me and say, well, John's making some horrible decisions. Horrible decisions do not necessarily translate into incompetency or incapacity. So you can't take somebody's rights away just because they're making terrible decisions. So if they're not legally incompetent, the court will not grant a guardianship. So mom is convinced there is a man sitting in the tree outside the house. She has a knife in case he gets inside. So these are, again, situations where if you have a power of attorney, it's easier perhaps to deal with it, or you may be bumped over into having to file a guardianship. So that's what we're talking about here. Dad was found 2 miles away from the house at 4 a.m. He said he was walking home, but he was going in the wrong direction. Dad is paranoid and thinks everyone is out to get him, including you. So if he doesn't have a power of attorney, he's not likely to give you one. And he's not likely to, because he thinks that you're going to take all his money. So it's best to get the estate planning, as I mentioned last week, early. Do it early before people, get up in age. So we don't have these questions of capacity, and they may not want to do it. They may become, hold everything close to the vest. Mom is abusive to dad. She hits him, yells at him, and recently stabbed him with scissors. So now when we get a violent act, sometimes we have no choice but to call 911 and DHR gets involved. And usually with a stent and Jerry psych, if it's a medication problem, they can be regulated. We still may need the guardian conservator if there's no power of attorney. If there's no power of attorney, you might not even be able to discharge mom. So we may need a guardianship for that. And then don't forget the conservatorship for assets. I mean, if you don't have access to her money and this happens, how are you paying the bills? So mom is not bathing properly. She's not eating properly. She's not taking her medications and refuses to allow caregivers to help her or move to a facility. Again, power of attorney is not going to help you much in this situation. So you have to come to somebody like us. A lot of good attorneys in Birmingham do guardian conservatorships, and you got to get the authority to take care of her person, but she has to be, adjudicated incompetent. And that means a doctor's letter and sometimes medical records. So again, every situation is unique. There's no one solution that's perfect for everyone. In these prior examples, with a power of attorney, care at home could be possible, but it may be impossible. So have they become a danger to others? Are they a danger of being harmed? So if this happens in a hospital setting, the healthcare power of attorney allows you to speak. I got a call yesterday that a man was coming into one of our clients' rooms in Jerry psych. He was another patient in a hospital, not in Birmingham. He was mistaking her for his second wife. So what that could lead to. And so we don't know if I mean, we know the mom doesn't have, or the lady doesn't have all her faculties. So, and she's claiming things happened. And so it's a mess, but the sons have a good healthcare power of attorney, and one's in Texas, but one's right there taking care of her. So we have to decide, what do we have the authority to do, right? That's why we need to have a financial power of attorney and a healthcare in place, so we don't immediately have to jump to guardian and conservatorships, right? Because they take time and money. Oh, and don't forget about the these horror stories you hear about, where remember when I mentioned due process, there are stories where people's due process were taken away when they were fine. I've been practicing for 32 years. I personally have not seen that. A person has a right to contest a guardian or conservatorship. Even if you provide a doctor's letter, they've got a right to be represented and contest it. And I know a lot of attorneys have seen that. We refer out a lot of the contested things because we focus so much on the pre-planning, helping people stay out of these situations to start with. That's what fills up our day. So here's an interesting one. This one always catches people. Your mother is married to your stepdad. She needs nursing home care, and you are learning that Medicaid counts your stepdad's asset in deciding if she meets the financial criteria. Your step siblings will not communicate with you and refuse to help you in any way. You don't know what to do because you cannot provide all the financial information to Medicaid and cannot use any of stepdad's money to pay the bills. So really, the power of attorney helps you on your mom's, but it doesn't help you, and you don't have authority to be guardian or conservator over your stepdad since he has children, your step siblings. So this is a rock in a hard place, but the takeaway from this is blended families, right? Second or later marriages, if you're in that situation yourself, and 65 to 75% of the country is in that situation. So not picking on anybody, I'm in that situation myself. So it's ripe for something to happen, what we call unintended consequences. So this is an unintended consequence of failing to plan for mom, but when she's remarried. So this is a very common, this is not the only problem that arises from blended families. Melanie and I do a presentation on blended families all by itself. But this one is, as it mentions down below on this slide, is that we probably need legal action to get mom qualified for Medicaid by providing the financial data, depending on how much stepdad, because remember, Medicaid looks at husband and wife as a unit. So this one is a tough one. But again, they're all fact dependent. They're highly fact dependent. So dad had a stroke. He was in the hospital, and then he was transferred to the nursing home for the rehab. They are telling you that you will need to start paying for him after the 20 days the rehab stint is officially over. So you know nothing about your dad's income and assets, and you do not understand the Medicaid process. So do you know where to look to find out about his finances? Are you just going through the desk drawer? I mean, some people have to do that. So do we have authority? So you may say, well, I can be a sponsor for Medicaid without a power of attorney, but how can you get all the data that Medicaid is requiring to see if he's eligible to actually apply? Are we prepared for the 5-year look back, the 5-year audit? So this is a good opportunity to tell you how we do that, is that, if the person can sign a power of attorney at this point, obviously we would do that. This may be one of those situations for a limited conservator. But on Medicaid applications, you say, well, why do you need a private lawyer to get public benefits like Medicaid and VA? Well, we have dozens of Medicaid applications, and I tell you why. Because yeah, they pay a legal fee, but we help them manage all the collateral information. And what we do is we go through all of that to see if there are any pitfalls before Medicaid sees it. And then if there is a plausible explanation, we can give to the caseworker to possibly make their job easier and to point out what may look like unusual cash transactions or a gift, but have if there's a legitimate reason for it, you're actually helping the Medicaid caseworker understand, where you're coming from. So you're helping them do their own work so they don't have to, dig into it as much themselves. Although, they have to obviously verify what we say. But that's a thought there. It's related to needing a power of attorney in this case. So again, real case, mom fell in the yard, broke her hip. She was already having some memory issues. She goes into assisted living. She cannot live by herself anymore, but you're not sure what is the best way to care for her and make her money last. So again, we're all guilty of this. We don't really know, in many cases, our parents' financial situation, because that is considered to be none of our business, and they may be private. Older people sometimes get real private. It's like these veterans don't talk about what happened in Vietnam and Korea. Do we have to get a limited conservatorship or a full conservatorship for you to find out about the finances and to possibly sell the house? Do you need to plan for the next level of care? That moving up from assisted living, it may be memory care, and then it's going to be Medicaid paying for skilled nursing or private pay. So you see all these situations where it's all about the authority that somebody has to help, generally the elderly person, but it could be a disabled person at any age. We never know what the next day is going to bring. So that's why we plan early and often. You don't necessarily have to plan often, but we tell people on their estate plans that to look at them every 5 years and to call us and let us ask them about a half a dozen questions to see and listen to their responses to see if they need a change. But a lot of people come in and their estate plans, including their power of attorney, is 20, 30 years old. So all right, so we had a big law change on January 1, 2012. Actually, that's when it became effective. So they wrote it prior. So there's the Alabama Power of Attorney Act that y'all seen, this little short power of attorney. I think it's 4 pages with a page of instructions on the front and a page of instructions at the back. That's called an Alabama statutory power of attorney. So remember I said that they were not forms. I meant the best ones were not forms. So Alabama is not recommending this power of attorney. Is Dr. Kraft, John Kraft, one of the law professors in Montgomery, I believe he was the main author of that. And he speaks on it, and they did the best job they could do, but it's like a one size fits all. In January 2012 and 013, 012 and 013, we did our power of attorney and we did the statutory for a couple of years because we didn't know if the banks were going to default and say, oh, we really only want to honor the statutory power of attorney. And the reason we thought that is because, Merrill Lynch or Charles Schwab or Ameriprise, they have power of attorneys for their own accounts. And sometimes they will send them an outside power of attorney and they say, well, our client didn't sign one of our power of attorneys. Well, guess what? It's too late at that point because the account holder has got dementia now. So, and I don't think that those companies, generally do a great job of saying, hey, you need to have one of our power of attorneys on file. If they did, and I'm not picking on those companies, but if they did, you'd have more people that had them on file, but it only acts for that account. So this standard little general power of attorney, sometimes it has a place to initial, and that's a little dangerous, because if you pull that offline and you do it, you're making a legal decision every time you initial something. And we want some of those initialed and maybe not necessarily the other ones. And that little statutory power of attorney, remember when I told you the blank check? You could, if I give you a blank check, you can take what's in my bank account, but if I give you a power of attorney, if all the boxes are checked on this, I have one attorney that calls it a license to steal. Now, the attorney, in fact, or the agent, is a fiduciary. You're only supposed to spend that person's money on them, which we'll get to in a minute. So we're talking about insufficient power of attorneys. So you think, oh, I've got a power of attorney. I've literally had people slide a power of attorney over to me at the conference table and say, oh, this power of attorney lets me do everything, and it's one page. Well, I mean, think about that. If you have, accounts with utility companies, you have stocks, bonds, real estate, annuities, funeral planning. I mean, if those things are not current, if they're not actually delineated in the power of attorney, checking the U.S. mail, then the power of attorney may not be sufficient. A power of attorney that just says, my son can do everything that I can do, is not good enough. So even though you have a power of attorney, you may be forced into the guardian conservatorship anyway. Well, that's bad, because you thought you had it covered. So again, anytime you hear the word probate, think time and money. And this is probate while you're alive if you're the incapacitated person. So your money is going to pay for a proceeding to take care of you. And then, for the nursing, I'll mention this a minute ago, while we're waiting on the power to get the to get the records. So this is an example of a power that needs to be in the power of attorney, and it needs to have trust powers. Now, a lot of attorneys will put, if they don't use the statutory, there's a little place to add this power in the statutory, number one, to actually add the other ones listed there. And some of those we may not want. Like, why would we want somebody to change rights to survivorship? That's very powerful. But we do need trust powers for the Alabama Family Trust. We need, if we want our agent, if say we have one child and we want them to be able to amend our revocable trust, or we want them to create a irrevocable trust. This is hardly ever in power of attorneys. So let's say we wanted to do some advanced planning and put some assets in an irrevocable trust to protect assets for mom or dad, so that when they do go into a nursing home, they're under, they don't have to, when they spend down to $2,000, and they've got some preserved to improve their quality of life. So that's a real thing, pre-planning. So, but this is making the point that power of attorneys may not have what you need. So power of attorneys sometimes don't have the authority to create a supplemental or special needs trust. They don't have the authority to use the AFT, the Alabama Family Trust. So you have to go to court, right? Because if the power is not in the power of attorney, you got to ask the judge to give the conservator the power. So it's not a general power. The power to create a trust must be specific. And
John, we have a question.
Shoot.
Can power of attorney, guardianship, estate planning, healthcare plan, and conservatorship be identified and addressed in a will with all family members and others being informed?
Oh, that's a good question. Yeah. So Yeah, I'm so glad that somebody asked that, because I haven't done a good job of stating that today. So think of this as disability planning. So a power of attorney ends at your death. So this is going to be a separate document than your last will and testament. And we make the healthcare power of attorney also a separate document than the durable power of attorney for finances. But the meat of that person's question is, I believe, is can we put that all down on paper where it's a joint, well, it's the person making the estate plan's choice, but they can, we routinely involve all the family members in it. So that creates the right expectations. Although, you have these problems where these situations where you've got 2 children in Birmingham and 1 in Portland, Oregon. Well, the one in Portland, Oregon can't very well be here, although we do have Zoom and conference calls. So but sometimes, some children may not be interested. They may want to leave it to the eldest one or the youngest one. But yes, you could get a consensus, but ultimately it's the person making the power of attorney's choice. But that's a great question. I had a couple in here a couple weeks ago, and the sons, or at least one son, came with them to the first meeting. And we do let the child come in there, the adult child, and but they came back by themselves, which is what I instructed them to do. And if they brought the son back, he would have to sit outside to make sure that I'm complying with their wishes. So they did not name that son for one decision making. He was power of attorney, but he was an executor. And when they got home that evening, he started, that evening, he started blowing up my phone saying that I had gotten it wrong. And I had looked in his parents' eyes and they told me exactly what they wanted. So I was in a real awkward spot there. So we didn't have a consensus. But the person who asked that question, you can come to a consensus and let everybody know what's in the documents. Now, if mom and dad are here by themselves, we tell them it's their choice, obviously, what to say and who to give the documents to. We recommend their documents, the estate plan is locked up with the people serving those roles, knowing what their roles are, but only accessing the documents when they have a need, like if they're in a lockbox in the house or a safety deposit box, something like that. But that's a really good question. So trust powers are generally not in a power of attorney, and neither are gifting powers. So again, we're making the power of attorney more powerful. Remember, blank check. But if you got really good agents, your children, you trust them, you may have co-power of attorneys where they both have to act together, then the more powerful the power of attorney, the more things that your agents can do for your benefit if you're disabled. So gifting here, I won't read you this whole thing, but gifting can be limited to $15,000 a year. And that's what's in the power of attorney mostly. But what if we want to gift hundreds of thousands to a trust to benefit the person, and we're leaving the heirs the same as under the will, but we want to do it for a little bit more advanced planning technique, either taxes or Medicaid. So if we don't have these powers in there, so I think I may be, y'all may be seeing that why a form is better than nothing, but it's not completely thought out if it's a real short power of attorney. Gifting, again, it's not a general power. If it's gifting is not in there, the person gives the power of attorney, the person making the power of attorney, the agent gives away that person's money, thinking that's what they wanted, then they're actually committing a crime. So that was in 2013 in protecting Alabama's Elders Act. So we had the new power of attorney in 2012, and then where the district attorneys can actually prosecute power of attorney abuse. So, the good thing is that when people come do their estate plan at attorney's office, we have several meetings with them generally, at least two. And so there's more thought, a little bit more thought to the process. And, we can tell if there's any undue influence or coercion or duress, and we make that, and that's our job. We're not supposed to let people sign it under those circumstances. Now, nothing prevents them from going somewhere else, but we try to do our part in that. Even when I was doing real estate closings, I used to say the people that commit fraud and do shady things, they don't want to sit around a conference table for an hour with an attorney, because we, doing real estate all the time, we would most likely see an irregularity. So this is getting into the misuse, right? So again, the agent or attorney in fact is a fiduciary. So just like a trustee or an executor, you got to use that person's money on them. It's just because you're the power of attorney or the attorney in fact doesn't mean you have a right to use it. That's a common misconception. They're very powerful, but you still need them. So you've got to strike that balance. There's some safeguards that I mentioned: the springing power of attorney, having two children having to act jointly, that kind of thing. So they definitely can be misused. So they have actually defined power of attorney abuse as exploitation. Somebody just has to be over 60. So, this is tantamount to stealing, or duress or coercion. They've gone in that Alabama statute to define financial exploitation: deception, intimidation, undue influence, force that exerts unauthorized control over the elderly person's property. Breach of fiduciary duty. See that right there? So they actually put some teeth into it, because if people are going to steal, most likely they're going to steal more than $2,500. So it's a Class B felony. But they went ahead and said that $500 to $2,500 is a Class C felony. This is a felony. Now, the district attorneys take this serious, and then a misdemeanor if it's under $500. So this is actually power of attorney abuse. I mean, this is a law that, that covers that. It also covers, other things like the deceit and theft by deception and things like that, but also covers power of attorney abuse. So as we talked about last time, if you don't know where to start, if you have a family you're talking with or your own family, one good way to start is an elder care action plan. Say you can get mom and dad started on it and help them gather up the stuff. And then this goes back to that person's question. This really helps to bring family members all over, adult children all over the country on the same page. We don't do enough of these. I mean, every time I do one, it's very gratifying, because we uncover things that the family knew, so they're prepared when something happens. It's really a good service. It tells the adult children where their assets and income are, if they're entitled to government benefits, the family dynamic, have they made any disqualifying penalties? Will they be eligible for VA in a couple of years? Do they have a service connected? We could get VA for that. So it provides actual recommendations, correct problem issues, tell the lay people what the levels of care, right? Y'all know the levels of care, but lay people get confused about that. They, ILFs, ALFs, SNFs, and SCALFs and SNFs, independent living, in-home care, independent assisted living, memory care, and skilled nursing. So once I explain it to people like that, and I do it as a stair steps, they get it. Oh, well, mom wouldn't qualify for that level. So that level cost X. So this is how long mom's money is lasting in this level. So we have to plan for the contingency that she's going to need the next level. So tying it all in, the power of attorney allows us to do that planning if she's incapacitated, or if she's not, it's done as a pre-plan. So you have that authority when she becomes incapacitated. Melanie wrote this slide. When we get this call a lot, when someone says they just need a POA, run. It's just not that simple. We got to see if they have capacity, second or later marriages. There's a thing called power of attorney shopping, where one child takes mom to get a power of attorney and the other child takes her to another lawyer to undo it. So we're watchful for that. Oh, look, almost hit it on the nose. But so questions, but I can also keep going because I know we need the CE. So pop in with questions now, but I'll keep talking, and Sean can tell me if y'all have any questions. But healthcare power of attorney. So what I was going to tell you about the healthcare power of attorney is everybody says, well, I have a living will or an advance directive. Y'all know the Alabama Advance Directive is a form that's much older than the statutory power of attorney. And it does let you appoint a proxy, the advance directive, but that proxy, you're only giving the authority over end of life issues, that is tube feeding and life support. So think about that a minute. That's not a power of attorney. That's one of those very limited things. So what do we need? We need a broader healthcare power of attorney, right? So, and sometimes you'll see a durable financial with just some healthcare powers thrown in there. And that's generally not a good idea, although a lot of attorneys do it that way. I'm not picking on them. But the bank doesn't want to see your medical preferences, and the hospital doesn't care who has, well, at least the medical personnel don't care who has financial authority. The business office might, but, so we do those as separate, so that, that modern estate plan on my slide last time is a will or trust as your foundation, a financial power of attorney, medical or healthcare power of attorney, living will, if you want one. Although we did do less living wills during COVID, because what does a living will say? It says no life support or ventilators. Well, people were surviving ventilators with COVID, and the family members couldn't get inside the hospital to advocate for them. I'm not saying that the hospital or staff did anything wrong, but you don't want any, that's one area you don't want any vagueness, any ambiguity, right? So, you don't want something that says, hey, I want a ventilator, just let me go, when people are surviving ventilators. So we beefed up our medical power of attorney and kind of held off on the living wills for a while, but encouraged our clients to have the conversation with their spouse, and adult children about how they felt about life support and tube feeding. So, the power of attorney gives them that authority. So that's the healthcare power of attorneys versus the living wills and the Alabama Advance Directive. Any questions, or do you want me to keep going?
Well, there are no questions thus far, John. I think you have overwhelmed us with information. I'm swimming. I mean, I thought I knew this, but I learned a lot today, and I'm sure everyone else did as well. And we thank you so much for being here with us today. Everyone, the code word for the Survey Monkey which I'm posting again in the chat room, the link. The code word is capacity. So we listened to you, John, and we've chosen capacity as our code word for today's survey. You need that in order to complete the survey. It's required, and in order to get your evaluation. Again, last time for the Survey Monkey address I'll give you is https://www.surveymonkey.com/r// all uppercase G D G G N H H. That's the Survey Monkey link. The code word is capacity. And John, we're getting comments. This was wonderful. Thank you. Thanks. It was wonderful, and we do appreciate you. Everyone, yes, Ms. Harris is asking if the slides will be provided. I have those. John has shared those with me, and if he doesn't mind, I'll share them with you.
Yeah, sure.
And I'll send those out with certificates this afternoon. I like to see give everyone time to do the survey. I used to close it at 5:30, but I found that some of you, well, many of you probably work well past 5:30 and don't get around to it. So I leave the survey open this evening, but I'll send the certificates out around probably 10 or so tonight. The website, Ms. Horn, again, is https://www.surveymonkey.com/r/ all uppercase G D G G N H H. That's the Survey Monkey link. The code word is capacity. Another comment. Thank you. Very informative, great information. And John, if you have questions for John, if you have clients in need or just need to run something by him, I'm sure he'd be happy to help you. His email is John, JOHN, at BradfordHolliman.com. And Bradford Holliman is spelled BradfordHolliman.com. John at BradfordHolliman.com. You're welcome, Melissa. Thank you all for listening in today. We're coming to the close of our hour. If there are no more questions and everyone has the link and the code word of capacity, I'll end the meeting and look forward to seeing John again. I believe it's next week, John. You're doing the VA aid and attendance pension for us, and I'm sure we'll have a lot of questions and learn a lot about that. I know that some laws have changed about that in the last couple of years since COVID. So
And
that'll be interesting.
And service-connected pension.
Oh, and service-connected pension. So this is something that will be probably new to many of us. So a lot of us have had the VA information before. This will be a great, not recall, but whatever, hearing it again. And then we'll learn something new as well, like we did today. So thank you so much, John. We do appreciate you.
Yeah.
We appreciate all
of you.
Thanks for the
opportunity.
You're very welcome. And we appreciate all of you on the call. We appreciate what you do. And we appreciate when you refer Care Patrol to families and seniors who are in need of free guidance and care and possible placement into communities. And certainly you can always reach out to me. Thank you all. Have a great rest of your day, and we'll see you later.